The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning. The first case is State versus Shuler, and we'll hear from the appellant.
May it please the court. I'm Mike Spivey, representing the appellant in this matter, Ms. Shanna Cheyenne. I'd like to reserve 5 minutes of my time for rebuttal. This court granted Ms. Shuler's petition for discretionary review to review the holding of the Court of Appeals in this matter that Ms. Shuler's silence at the time of her arrest was admissible during the state's case in chief at her trial because she complied with 15A 905C1, which required her to give notice of her intent to assert a duress defense. Ms. Shuler had argued in the trial court that her silence was inadmissible under her Fifth Amendment right to remain silent. The trial court addressed the issue by ruling that Ms. Shuler was not under arrest and that she had not been advised of Miranda, and thus her pre-arrest, pre-Miranda silence was admissible. On appeal to the Court of Appeals, Ms. Shuler argued that the trial court's ruling that she was not under arrest was incorrect and that her the admission of silence was error. The Court of Appeals did not directly address the constitutional issue that Ms. Shuler raised. Instead, the court went to 15A 905C1 and said that because she had given notice of her intent to assert a duress defense, the state was entitled to offer evidence of her silence. I've been unable to find any authority to support that position, and the Court of Appeals did not cite any authority to say that 15A 905 operates to in some way work a waiver or forfeiture of a defendant's Fifth Amendment rights. 15A 905 is clearly part of our statutory discovery.
On a broader level, did you find any authority that you could impeach a person before he or she testified?
The authority in the Court of Appeals was that the state could not impeach her by silence prior to her testifying. And that was State versus Mendoza. The court distinguished Mendoza because it said 15A 905C1 applied, and since she had given the notice of intent to assert a duress defense, Mendoza did not control the issue. Clearly, I think that the Court of Appeals misconstrues the effect of 905. It's a discovery statute. It has no bearing on the admissibility of evidence other than in the context that if there is a discovery problem and a party has not complied with discovery and is being sanctioned, it could affect their right to offer evidence in that context, but it does not otherwise control whether evidence is constitutionally admissible or not. So I think that in the context of this case and on this limited issue, the Court of Appeals clearly erred and it should be reversed, and this matter should be remanded to that court for it to address the constitutional issues that were raised by Ms. Shuler in that court.
Can you comment about the precise question that the trial court allowed?
The trial court allowed an officer to testify that at the time of what she argues was her arrest or after her arrest, the trial court asked the question of whether or not she made any comment about Mr. Warren, who was another occupant of the vehicle and present at the scene. Her duress defense would ultimately rest around whatever threats he purportedly made. So the officer was asked whether she said anything at all about Mr. Warren at that time, and the officer was allowed to testify that she did not.
So there was not a broad question with regard to did she say anything, but simply did she make any statement about Joshua Warren?
That's correct, Your Honor. If the court does not have further questions, in the absence of any authority supporting the position of the Court of Appeals or the state in this case, that would conclude my argument.
Thank you, counsel. We'll hear from the FLE.
Members of the court, I'm an assistant attorney general for the state of North Carolina, and I'll be presenting the argument on behalf of the state today, the appellee. Now, the state contends that the holding of the Court of Appeals opinion in the case at bar shows that once defendant has clearly shown that she intends to cast aside the cloak of silence, then the state can impeach the defendant with pre-Miranda silence during its case in chief. So with that in mind, the Court of Appeals correctly affirmed the decision of the trial court that allowed during the state's case in chief testimony from law enforcement that the defendant did not say anything about the person she was with while she was detained by law enforcement.
But Mr. Kazai, I'm going to ask you the same question I asked Mr. Bivey. Can you cite me any authority that allows the impeachment of a witness before that witness testifies?
Well, I was before we came on live. I usually for the Supreme Court cases, I try to look at every court case that is cited, and I did a little Shepherd's of Miranda and found about 50,000 cases and figured out.
I'm talking about impeachment in general. My question's not limited to impeachment by pre-arrest or post-arrest silence. Can a party impeach a witness for the purpose of attacking that witness's credibility before that witness testifies?
I did not find any court case in my search that showed that it can be used as impeachment during the state's case in chief. It was only used in those cases that was used, it was found to be used as substance evidence of the crime.
But your argument here today, I think, is that what happened here was that the defense of duress was entitled to be impeached. That seems to be what the Court of Appeals held. Is that wrong?
That's the interpretation of the state, that the Court of Appeals decision made a narrow exception that if the state, it's clear that defendant is going to cast aside the cloak of silence, which we contend that it was clear in this case, then the state can impeach the defendant during its case in chief, that it was impeachment and not used as substance evidence.
All right. So is the answer to my question of whether a witness can be impeached prior to that witness's testimony under any authority that you're aware of to date other than this case? Is the answer to that question no?
That's my interpretation. I didn't find any cases out there that found it as impeachment evidence.
And that's what your contention is, that this evidence is permissible for, right?
That's correct.
Okay, thank you.
It's a very narrow exception when it's clear that. Yes.
She gave the state is arguing that the notice that she sent of intent to assert certain things waived her right to silence. Is that right? No,
Your Honor, that is not what the state's contending. The state's contending that it's not waiving defendant's right to silence at all. That would be in conflict with Doyle versus Ohio, and it would be
used against her in the trial.
It can be only used. Pre-Miranda silence can be used. It's only in pre-Miranda silence, and it can be used in the state's case in chief if it's clearly shown that defendant has intended to classify the cloak of silence. But we don't want the situation where defendant provides a notice under 905C, and then she gets to court and she decides that she's going to not rely, and she informs the trial court, I'm not going to rely on the duress defense, and that we say, well, she's already waived that right now. That's not what this case, the Court of Appeals decision held.
Well, she still could have decided not to testify, correct?
She could have decided not to testify, but she wouldn't have had a defense. At that time, the state contends that this is not a situation where the defendant had any choice. The only defense she was going to have is a duress defense. She was found in possession of both the meth and the marijuana. She not only possessed it, she pulled it out of her bra, both of those items. So the only defense she was going to have, so the state contends that the fact that the state attempted to impeach the defendant during its case in chief did not force the defendant to take the stand. If she had
decided not to testify, what would the state's argument be?
Well, the state that would put the state in an interesting argument. That's for sure. I recognize that, Justice Hudson. I guess the first argument would be is harmless error. And the Court of Appeals opinion did not get to that issue, whether or not this was harmless error. But that would be the state's primary argument is, okay, if it was error to allow this, it was harmless error. The next question is whether this was actually substantive evidence. Then, if it's not impeachment because the defendant didn't take the stand, then if it's admissible as substantive evidence, then we go back to the State versus Boston case, the 2008 Court of Appeals opinion, which held that substantive evidence could not be used either pre or post Miranda. Now, this court and the U.S. Supreme Court has not decided that issue. So this court may wish to address whether or not the state is entitled to use substantive evidence impeachment during its case in chief.
So under the statute, was the trial court required to notify the jury before impanelment that the defendant was presenting a duress defense?
Yes, under 15A 1213, the trial judge was required to inform the jury of that the defendant had notified the state of the duress defense. Now, and if the defendant had not taken the stand, Justice Hudson, then that would have put the trial judge would have had the authority to inform the jury at the close of the state's evidence, close of the evidence that the defendant had not indeed relied on that duress defense.
Isn't it conceivable that there's other ways she could prove she was under duress other than her own direct testimony?
Well, she attempted to do that, I guess, through calling Joshua Warren to the stand. Under the case, she called Joshua Warren to the stand, and that was the person she was with at the time of the detainment. And he testified that he had not threatened her. So she kind of impeached her own testimony at the time. So she could have relied on him, and hopefully he would testify that, yes, he threatened her with bodily harm, which then she could have got it in that way. But that's not the facts of this case.
Right. But my point is, in general, that just because someone indicates an intent to advance a duress defense doesn't mean that they necessarily must themselves testify.
That's correct.
And couldn't this, once she had testified, then the state could use this to try to impeach her?
That would have been, we wouldn't have the issue here if they had followed the normal procedure, then we wouldn't have this case here today. And I spent a little time in my brief, and I'm no criminal lawyer by no means, but I do think this case is a good example of where it's best for the state to wait, and to defendants actually taking the stand to attempt to impeach her. In this case, the state did not even try to impeach her with the use of the prior Miranda silence during the time she testified. They didn't address that issue at all. So I don't, of course, that mostly goes to the harmless error issue, but the state puts itself in a very awkward situation if here they decide to go ahead during its case in chief to attempt to impeach the defendant with pre-Miranda silence, and then the defendant doesn't take the stand, of course. And it's always, I mean, and as you pointed out, it's possible that if the state's evidence regarding the amount of the weight of the meth failed, then the defendant wouldn't have taken the stand. So it's not only is the fact that sometimes the defendant can get in other ways, her evidence of duress defense, but it's also the case sometimes the state's case falls apart during this case. So it definitely puts, at least the Attorney General's office is not recommending that the district attorney start using this across the board. But I think that because of the few cases out there in North Carolina, there is attempts by the district attorney to kind of, I call it preempt and take charge of the case. And the question, of course, before this court is whether this court decides it is every case in which the state attempt to impeach the defendant during its case in chief with the prior use of pre-Miranda silence, is that going to be considered substantive evidence? If it is, then we don't have the question of whether the impeachment issue, we just have the question of whether this court should choose to affirm State versus Boston. When Boston came along in 2008, this court did not grant discretionary review at the time. So that issue's not been decided. And the Attorney General's office, please don't let this be that the Attorney General's office is taking a position on that issue. I don't have the authority to tell you what the Attorney General's office has said regarding pre-Miranda silence being considered a substance evidence. Personally, I question the use of silence as to impeach anybody in today's time or any time. But in this case, I think it's important that, as Chief Justice Newby pointed out, this case did not rely, the Court of Appeals did not rely exclusively on 905C1. It also relied on the fact of 1213, 15A 1213, that the trial judge informed the jury. And it also, if you look at the transcript, you see that here this defendant clearly showed that they intended to present, or she intended to present, a duress defense.
What's the state's perception of the requirement for a trial court to let the jury know that there is an affirmative defense being lodged by a defendant?
It's required under 15A 1213. I don't understand your question. Or
it's a requirement by the it's a requirement by the statute that the trial court do that.
Yes.
What is the state's perception as to the rationale for such a statute to exist to put such an onus on a trial court?
I don't know. I surely can't speak for the Attorney General's office. I've never addressed that question. I guess I guess it was the idea that and part of discovery that with the interplay, if defendant, before 1973, there was no discovery statutes in criminal cases, so neither the state or defendant had a right to discovery. So the General Assembly passed Article 48 that allowed discovery, and the idea behind it was that if it would lead to more organized trials and also lead to more likely the truth to come out. So there was concern that sometimes defendants would try to tailor their argument in light of discovery they got from the state. And I think, and I haven't read, I don't know if there's any minutes available regarding when they passed, 1213 was passed in, I think that was passed in 1977. So it was 4 years after 905 added. And maybe it was just the idea that some defendants were taking advantage of it. And that's just speculation on my part. I don't know there's any minutes available by the General Assembly why the General Assembly passed the statute. I deal mostly with federal courts, and of course you can read the congressional minutes ad nauseum about what the purpose behind the statute is. But here, North Carolina doesn't have that.
Well, let me ask it this way. I wasn't trying to ask you a trick question. My approach is this, from the state standpoint, in terms of having knowledge, as the jury would and as the state would, that the defendant is lodging an affirmative defense. How is the state then, in having the burden of proof and the burden of production, to go forward in the presentation of its evidence in a case in which a defendant is lodging an affirmative defense?
Forward with presenting the elements of the crime, of both crimes. I'm sorry, I still don't understand your question, Justice Morgan. As it did in the case of Barr, are you saying that regarding the duress defense?
Is the state allowed to tailor its presentation of its evidence based upon the knowledge that a defendant is lodging an affirmative defense?
If it's clear that defendant has tended to cast aside the cloak of silence, then yes, I think during its case in chief, then it can use pre-Miranda silence to tailor that.
Not knowing whether or not a defendant is going to testify or not, but knowing that there is going to be an affirmative defense lodged, what would be the parameters of the state going forward with pre-Miranda silence being shown?
Well, it does so at its own peril if it chooses to cross-examine a detective about pre-Miranda silence during its case in chief addressing the duress defense. It can do it, but it's doing it so at its own peril when it does, because if the defendant does not take the stand, then it subjects itself to the trial judge upon objection, maybe calling a mistrial. Or the Court of Appeals or this court reversing the decision, allowing the admission of the evidence. I'm trying to answer your question. I don't know if I am, Justice.
All right, and it may not be the most artfully asked question, but you've answered them. Thank you.
Okay.
I'm sorry. Let me try to follow up. I think we all understand that the state can't use defendant silence to prove guilt. But here, there was already evidence of marijuana possession and methamphetamine possession when the defendant produced those items. You would agree with that?
That's correct, yes.
And that has nothing to do with her silence at any point.
That's correct.
So does her silence here relate to her guilt or to her affirmative defense?
Well, it's the state's contention that it relates to the affirmative defense. But on behalf of the defendant, I will point out, I think it's the State versus Lane case, which is kind of a landmark North Carolina Supreme Court case where the defendant raised an alibi defense, and this court held that impeaching that alibi defense was going to as substantive evidence. So I do think there's a distinction between here, the impeachment, to the extent it was impeachment or substantive evidence, whatever, went to the fact of whether or not her duress defense, not to the elements of the crime. Now, whether or not that's going to be a distinction this court wants to make, it's up to this court, of course. But I do point out the State versus Lane opinion that I think it's at least dicta in that case that says that, wait a minute, impeaching the defense is also going to the elements of the crime.
I mean, Mr. Kazan, just to follow up on that a second, the purpose of this evidence, as I understand it, was to sort of launch a preemptive attack on the defendant's claim that she was subjected to duress. Is that right?
That's correct. Yeah, I mean,
You
yes.
know, the purpose of impeachment, at least as I understood it back when I used to do it, was to cast doubt upon the credibility of the testimony provided by a witness.
Yeah.
I mean, do you agree with that?
Oh, 100%. Yeah, it's,
I mean, and there are lots of different ways that you can attack the credibility of a witness. I mean, you can cross-examine them by prior inconsistent statements. You can also ask them about their prior criminal convictions within the scope of the cross-examination allowed by the rule of evidence. Could under the logic of this case, would the state have been allowed to put evidence in its case in chief regarding the defendant's prior convictions for the purpose of attacking the credibility of her duress defense?
during the state's case in chief,
In the state's case in chief.
the state would contend that the state would not be allowed during the state's case in chief for the defendant to put on evidence regarding the defendant's prior criminal record during the case in chief.
So generally, to go back to my former question, it's not permissible to elicit evidence in the state's case in chief for the purpose of attacking the credibility of the defendant's claim. So what you're asking us to do in this case is to create an exception to that general rule. Is that a fair assessment of the state's position?
Yes, on the caveat, it's an exception where the defendant has clearly showed that she intends to waive her right to silence.
And if that's part of the test that you're asking us to adopt, other than the fact that the defendant gave notice of duress, of the reliance upon the defense of duress, and other than your belief that the only way that the defendant could have asserted that defense was to testify herself, what other evidence is there that the defendant was bound and determined to take the stand in this case?
Well, before jury selection, the state and the defendant, the district attorney and the judge and the defendant's attorney, trial attorney, discussed having Joshua Warren, that's the person she was with, transported from prison to the court. And they discussed about waiving his right to an attorney, or having an attorney present and what he'd be dressed in. So that would be the other evidence before this court on that issue. Now, defendant waived his opening argument before the jury and waited until after the close of the state's case. So his duress defense did not come out in front of the jury except for the mention by the trial judge. So that would be the other evidence that it was clear to the defendant, to the state, that it was defendant's intention to rely on the duress defense. But
is that evidence that the defendant intended to testify, or is that evidence that the defendant intended to try to show a duress defense in general?
Well, that's only evidence that defendant was going to present a duress defense. But if in this case, I think it can be, well, defendant did call Joshua Warren and he did not present a duress defense.
From what I can tell, that didn't go very well.
Yeah, that didn't go very well. So I guess the state pretty much knew that unless Mr. Warren just decided to waive his right to remain silent himself, that the only way they were going to get in that duress defense was defendant to take the stand. So, I mean, this case is it's a little different than the defendant pointed out the State versus Mendoza case, which, of course, that is a case that maybe the Court of Appeals opinion could have distinguished a little bit more and spent a little bit more time on it than they did to decide that it wasn't controlling. But that case was about constructive possession, where this is actually a case about actual possession. So here, the state pretty much had the case wrapped up as long as they had their person could come in and testify about the weight of the weight, and the detective could just recall that she pulled it from her bra, they had their case wrapped up. So it was reliance on the defendant had to come forward. So the actual and constructive position, we contend, it makes this case different. Now, whether the court wishes to make that distinction, but as Justice Irwin's pointing out, I mean, it does in every case, once the defendant takes the stand, is the state allowed to impeach defendant during the case in chief, or is it always considered substantive evidence? And that's the critical issue here.
Does a defendant give up anything in terms of his or her rights by lodging an affirmative defense?
Except for the fact that they give up the element of surprise, because 15A1213 kind of erases the element of surprise with the jury. And of course, they give up, by the fact they've raised the duress defense, they give up the element of surprise to the state, because the state can prepare for that case as they did in this case. So I do think that, but defendant does give up certain, I don't know if you'd say rights, but at least some of the court tactics, strategy, by having to go in discovery and get discovery from the state. They do give up some kind of discovery. I mean, trial strategy.
In a sense, this case is about parameters, in my view, as a defendant lodging an affirmative defense, letting the state know that, then the state is in position to know what the defendant's strategy may be going into the presentation of the state's case in chief. With that as a premise, does the state perceive that the defendant is, while perhaps not giving up rights, at least having some surrender of an opportunity to lodge other rights, such as a right against self-incrimination or other rights, because the state now has this information?
I don't want to, I'm not going to go on record that defendant's giving up any rights, but he definitely loses trial strategy by discovery. And once they get to trial, if under the Court of Appeals opinion, they get the right, I mean, they lose the opportunity of being able to so-called spring the element of duress on the jury. Of course, 1213's already removed some of that, but they still have the right to remain silent and not take the stand. Of course, if the state's already tried to impeach them, at that point, the state's in a precarious situation.
Can I ask just a quick question about the harmless error argument?
Yes.
Because isn't it true that in this case, it's the state's burden to prove that beyond a reasonable doubt, if we can find that there was error, that that the harmless error standard is beyond a reasonable doubt, because this was objected to at trial and it's a constitutional right at stake.
And you know, the Court of Appeals didn't address the harmless error, and if this court finds that the Court of Appeals opinion is not correct, then the state would ask that it be remanded, the case be remanded back to the Court of Appeals to address the harmless error. But
and to follow up on Justice Earl's question, I mean, I don't remember the identity of the proper harmless error standard being something that was debated at length in the briefs that you and Mr. Spivey filed. Is my recollection to that effect correct or not?
Well, the defendant's brief doesn't address the harmless error in front of this court because that was not addressed at the Court of Appeals. And I addressed it just because that's one of my strongest arguments. I want to sneak it in there, I guess. But it was not addressed by the Court of Appeals. So that's probably why the defendant didn't address it, because it wasn't addressed by the Court of Appeals. But I do spend a little time on my brief talking about just the fact that this impeachment, whatever it was during the state's case in chief, didn't really do anything really. And it really wasn't impeachment until the state, the defendant made his opening argument to the jury at the close of all the state's evidence that it come out that this was maybe impeachment, but it was a sloppy way of impeaching somebody, if anything at all. But thank you. I'm about out of time here. The state does recommend that the court affirm the Court of Appeals opinion, but if it chooses not to, that it remand back to the court to address the harmless error issue. Thank you.
Thank you, counsel. Rebuttal.
The state said in its brief that there are a number of intriguing and interesting constitutional issues involved in this case, and that is absolutely correct. There are. The problem is those issues are not before this court because they weren't decided by the Court of Appeals. And the court did not grant discretionary review of any issue other than the question of whether the application of using 15A 905C1 to say that somehow operates as a waiver or forfeiture or opens the door, however you want to term it. It was error for the court to apply that discovery statute to say it affects or determines the admissibility of evidence at all in this context. As I said earlier, if this were a sanctions context because the defendant didn't offer the notice, then sure, it would have some bearing. But it has no bearing in this context, and it creates a major problem for defendants because there is no question if the Court of Appeals opinion stands, any defendant is going to have to think long and hard before they even seek discovery, and certainly before they give notice of an affirmative defense about whether they're waiving constitutional rights simply because they comply with the discovery statutes. That's the narrow issue. That's the error. And that's where the problem with the Court of Appeals decision is. Now, what they will ultimately hold if the court remands about the arrest issue, whether she was under arrest or not, how they will address the issue of whether this was pre-arrest silence or post-arrest silence. All those are interesting issues, but they're not here now. So I would ask the court to limit its ruling to the precise issue before the court and hold that the Court of Appeals erred and remand the matter so that we can address, or the Court of Appeals can address in the first instance, those other very interesting issues.
Thank you, counsel. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court. All right, thank you, counsel.